Looking deeper into the American justice system, we have found inequalities for the impoverished. Thus, we will look into making the justice system just by implementing a nuanced procedure of pretrial detention and conviction consequences. The justice system in America is a democratic system that was founded on freedom and equality. The Bill of Rights was written to protect the rights of all citizens under law. The system seems sound, but many fail to realize that it does not equally protect the impoverished. We believe the two most concerning poverty-related issues with respect to the United States justice system are pretrial detention and collateral consequences of conviction because they restrict employment options, certain rights, and create sometimes significant financial burdens. We believe these issues can be addressed by changing bail procedures and providing ex-convicts with easier integration back into society. We will begin investigating the inequalities for the poor by looking at bail. When arrested for a crime, people will be taken to jail and a bail bond is set. Essentially, this means that while waiting for the commencement of your trial, you may pay a bail fee and await your trial out of jail. The fee is to ensure your presence at your trial, so once you show up in court, you get your money back. 70% of people who are in jail are awaiting their trial. For most of these people, their jail time will only last a couple hours before they pay their bail, but those who cannot afford the cost will remain detained until their trial. People in local jails unable to meet bail are concentrated at the lowest ends of the national income distribution, especially in comparison to non-incarcerated people. As this graph shows, 37% had no chance of being able to afford the typical amount of money bail, since their annual income is less than the median bail amount. The median bail bond amount in this country represents 8 months of income for the typical detained defendant. There are many problems faced by those who cannot afford their bail. The employed will miss work and may face losing their jobs. Those who have family members to care for will be unable to from behind bars. Furthermore, those in jail may face threats to their physical welfare. In 2011, correctional facility executives reported over 8,500 assault allegations. Other than waiting in prison for their trial, those who cannot afford bail can get aid from bail bond companies. The bail company will pay your bail but usually charge a fee of around 10% of your bail, meaning the company gets the bail money back plus the 10% of it that you paid. This makes it difficult for those living in poverty because there is still a cost. Additionally, most companies won't post bail less than $2,500, so if your bail is less than that, you're out of luck. An alternative is taking a plea bargain, meaning you plead guilty to receive a lighter sentence. Many people in poverty are wrongly convicted of crimes and have no means to prove their innocence because they cannot afford proper representation. Since Gideon v. Wainwright only guarantees a lawyer in criminal cases and trials, defendants will not be guaranteed a lawyer in a pre-trial bail hearing. Without a lawyer, people may not understand what the bargain entails, thus this is a disadvantage to the poor. There are pros and cons to pleading guilty, of which include a shorter term or potentially no jail time and instead community service, and cons include they have no right to an appeal and may have difficulty getting a job in the future. Are you really innocent until proven guilty? Studies have shown that judges and juries can be swayed by what a defendant wears. Few courts provide alternatives to jail clothes, thus leaving the defendant in jail clothing for trial, which increases the likelihood of being found guilty. Therefore, because the poor are more likely to end up in jail due to inability to pay bail, they are more likely to appear guilty and be convicted. Additionally, collateral consequences of conviction are legal restrictions that limit people with criminal records from accessing employment and other societal opportunities. So what happens when you are convicted of a felony in the state of Virginia?
If you are convicted of a crime, you are unable to reside in a family home or a foster care home, and you cannot reside in a home with a person serving as a caregiver who is being paid by the government, but you can live in these places after 5 years. This restriction results in limited housing options for ex-convicts and can leave many of them homeless. The likelihood of a convicted felon receiving employment is significantly lower than an individual who has not committed a crime, which can be because many working licenses are suspended post-conviction. According to the New York Times, men with criminal records account for about 34% of all non-working men ages 25 to 54. In Virginia, when an individual is convicted of a drug offense, the driver's license is automatically suspended. And in Richmond, Virginia, 75% of jobs are not easily accessible via public transit for people living in low-income communities. When people cannot find work, they turn to criminal acts in order to get money. Although the government has tried to come up with a solution, it is not certain to be beneficial in the long run. The federal bonding program gives bonds to employers to take on felons for 6 months, but when these 6 months are up, employers can let go these ex-convicts. This program temporarily solves the unemployment issue and still leaves ex-convicts with limited job opportunities. Phone calls cost 4 cents per minute, and the average phone call costs 69 cents. If an individual is in poverty and cannot afford phone calls, then they may not be able to contact their families, employers, or landlords and explain their situation, which may lead to job loss or eviction. The cost also adds up to be a financial burden. You cannot vote if you have been convicted of any felony unless you complete the Restoration of Rights program. This program is a very long process, which means that many ex-convicts struggle to complete it. To be eligible, an individual must have these 5 things. Additionally, you need to present 3 letters of reference. The caveat is that if an individual does not pay their court fees, they are not eligible for this program. In many states, convicted felons are banned from receiving TANF and SNAP. About 3/4 of the United States still enacts either a full or partial ban on government welfare for ex-convicts. The implementation of this ban can serve to be detrimental to families. Innocent children are forced to face the consequences of their parents' actions. As previously stated, the poor are more likely to be convicted of felonies. People living in poverty often do not have the money to pay off court and incarceration fees. This results in debt accumulating and prevents these individuals from taking advantage of certain opportunities. This includes programs such as the Restoration of Rights program, and also includes job opportunities. Conviction worsens the financial situation of impoverished individuals because it makes it exponentially harder for these people to receive jobs. Employers do not want to hire ex-convicts, and the suspension of work licenses can limit job opportunities. Lastly, the suspension of driver's licenses serves only to worsen the financial status of the impoverished because in many cases it prevents them from getting their jobs or job interviews.
So the question remains, how do we help those who cannot help themselves? The government's previous attempts include the following.
The Ban the Box campaign was the government's attempt to have private employers remove the box on job applications that requires you to check if you have a criminal record. Because they had no knowledge of criminal offenses, employers began to assume that individuals with African American names had a higher likelihood of committing crimes in the past. Thus, job applicants with African American names got fewer callbacks. This led to a racist issue that only served to promote white individuals and diminish the job opportunities of African Americans. In 1998, Hawaii was the first state to ban the box with the Fair Chance Law. This law prohibits most private employers from inquiring about criminal history until after making a conditional job offer. If the offense is relevant, employers are permitted to revoke the job offer. Additionally, employers may only consider an employee's conviction record within the last 10 years. This gives ex-convicts who have been convicted years ago an opportunity to redeem themselves and join the workforce. After the Fair Chance Law was implemented in Honolulu, repeat felonies decreased by 11.4%. This means that more ex-convicts were receiving jobs and therefore they weren't turning back to illegal ways to earn money. This graph illustrates the effects of the Ban the Box initiative on employees with criminal records from 2011 to 2014. Ban the Box served to increase the number of hired ex-convicts from 2.3% to 15.5% in 4 years. Clearly, the implementation of the Ban the Box served to improve the unemployment rates among convicted felons.
Our proposed changes include the following. To help those who cannot afford bail, we propose an anklet system. The point of bail is to get defendants to attend their trial, so this system implements house arrest anklet technology to serve the same purpose. We suggest that if one cannot afford bail, they are given the option to wear an anklet until they return to court for their trial, and at that time the anklet will be removed, similar to bail money being returned. This will provide an equal opportunity for citizens, no matter the income. Some may argue that this will make these people outcasts in society, but we refute that at least they're in society rather than being locked in jail. Furthermore, they may cover it with a pant leg or sock. This system will save the government money because less will have to be spent on mass incarceration. The Fifth Amendment states that no individual shall be compelled to testify against himself. Wearing prison clothes in court essentially testifies against oneself because it causes bias from the jury and the judge and increases likelihood of the defendant being found guilty. If we install the anklet system, this will not be a problem as those who cannot afford bail will no longer be coming from jail. To help those in poverty re-enter the workforce, we propose that we continue to push for the Ban the Box system, but implement a number system to reduce the racial gap. This system will replace applicants' names with numbers so that callbacks will not be racially biased. To reduce housing difficulty for ex-convicts, we plan to develop the halfway house system. Halfway houses are privately run but receive government grants. These houses provide shelter and training for ex-convicts as they reintegrate into society. The Trump administration recently decreased funding for these houses. Prior to the change, about 249 halfway houses across the United States were supported by 180 government contracts. The Trump administration has severed 16 contracts in the past several months and is continuing to cut support. We believe a solution could be to restore funding for these houses. To restore voting rights, we believe the Restoration of Rights system should be less complex so that individuals are motivated to restore their rights. Furthermore, to make it equal for all income levels, we believe ex-convicts should be allowed to restore their rights, even if they have not paid off all their incarceration fees. Lastly, to limit the money that the incarcerated have to pay, we propose that we make phone calls in jail free and reduce and/or subsidize court fees.